If you're subject to a non-solicitation clause, you may be wondering to what extent you can compete with your current or former employer. I'm Mike from Cash and Legal, and in this video, I'm going to cover what does and does not constitute solicitation under a non-solicitation clause. Before I get started, I want to stress that this is a fact-specific analysis. The important thing to clarify at the outset is that the analysis provided in this video is general in nature. Any non-solicitation clause must be thoroughly read and understood in order to determine what is permitted and what is not permitted under the specific terms of that clause. Those specific terms will dictate which activities you can and cannot engage in. If you are subject to a non-solicitation clause and you are looking to compete with your current or former employer, I encourage you to click the link to our website in the description to this video and book a consultation with our office today. With that out of the way, let's talk about what constitutes solicitation. In the context of competing with your former employer, solicitation refers to demonstrable efforts to secure business from one of your former employer's clients. What distinguishes solicitation from normal competition is effort and intention. Specifically, how much effort and intention do you direct towards obtaining business from a particular client? Just because you are competing with your former employer, that does not mean you are necessarily soliciting clients from their business. Solicitation requires a level of active persuasion that goes beyond competition. With that in mind, it is helpful to have an understanding about what activities constitute solicitation and which activities do not. Firstly, general advertising is not solicitation. If you are competing with your former employer and subject to a non-solicitation clause, you are allowed to generally advertise for your business. Advertisements are broad announcements to the general public about your activities. Advertisements are generally not directed towards a specific individual and are not designed to persuade a specific client to do business with you. For this reason, publishing broad advertisements online or in traditional media will generally not constitute solicitation. So long as these advertisements are general in nature, you will be on side of your non-solicitation clause. Even if a client of your former employer sees the advertisement and ends up doing business with you, this is not a breach of the non-solicitation provision. However, with that broad advice in mind, as I said at the beginning of this video, it is important to be mindful of the specific activities that might be restricted under your non-solicitation clause. It's also helpful to know that courts will generally take a very narrow view of non-solicitation clauses. There's a general understanding that contractual terms that limit a person's ability to do work are contrary to the public interest. The reason for this is twofold. One, competition in the marketplace is good for consumers, and two, people should be allowed to pursue their livelihoods. For these reasons, courts will always construe a non-solicitation clause as narrowly as possible. If a non-solicitation clause were interpreted in a way that included general competition, this would render the non-solicitation clause effectively a non-competition clause. This is something that courts will almost always try to avoid. Another important component of non-solicitation clauses to consider is the level of proof required by the employer to prove breach of a non-solicitation clause. If you are subject to a non-solicitation clause and competing with your former employer and end up doing business with one of your former employer's clients, they may allege that you are in breach of the non-solicitation clause. However, if you did not actually solicit business from that client, meaning if you did not engage in any kind of active effort to persuade that person to do business with you, you would not be in breach of the non-solicitation clause. Regardless, your former employer might assume that you were in breach of the non-solicitation clause and pursue a claim against you. But in the absence of concrete evidence proving your efforts to solicit business from that particular client, the claim is unlikely to be successful. There is a major caveat that I want to share on that last point. Even if you did not engage in active solicitation when competing with your former employer, this does not mean that the non-solicitation clause will not cause any negative consequences for you. As I just indicated, practically speaking, your former employer may still pursue legal action against you even if you did not technically breach the clause. Although you may be successful in defending this legal action, you will still suffer some negative consequences. You will incur legal fees for a prolonged period of time, and you could damage business relationships throughout this process. These are risks that you need to be mindful of when competing with your former employer if you are subject to a non-solicitation clause or any other kind of restrictive covenant. If you are subject to a non-solicitation clause or any kind of non-compete clause and you're considering competition with your former employer, we can assist you. We provide employees who are subject to non-solicitation clauses with clarity about their circumstances, strategy for next steps, and peace of mind through sound advice and strong representation. If you have more questions, click the link to our website in the description to this video and book a consultation with our office today.